The Great War of 1914 to 1918 was often called the War to End War. It was thought that after the horrific slaughter of the First World War, the nations of the world would seek more sensible ways to resolve disputes. Sadly, war continued almost immediately. One example was the Greco-Turkish War of 1919 to 1922. At the end of the First World War, the victorious Allies gave Greece land which had been part of Turkey, one of the defeated nations. At the same time, the old Sultanate of Turkey was overthrown in a revolution which created the modern Turkish nation. The new Turkish regime did not accept the loss of land, and when Greece sent troops to occupy those lands, the Turks responded with military force, pushing the Greeks back to their previous borders. The peace treaty which concluded the Greco-Turkish War included provisions for a population exchange, where Greek Orthodox Christians living in Turkey would return to Greece, and Turkish Muslims living in Greece would return to Turkey. There were some exceptions, most notably Greeks who were established in Constantinople, now Istanbul. These Greeks were the commercial heart of Constantinople, and if they had emigrated, the city's economy would have suffered terribly. The difficulty came from the word established. Only those who were established in the local area were to be exempt. This was intended to prevent people who did not want to leave Turkey from simply moving to Constantinople and claiming to be exempt. However, the two nations disagreed as to the meaning of the word established. Turkey said that its national laws already defined the word established, and this meaning should be applied to the treaty, at least as it applied in Turkey. The court disagreed. The court found that the treaty was an international agreement, and that if there was a conflict between the treaty and national law, it was national law that would be required to be amended. The court described a principle which is self-evident, according to which a state which has contracted valid international obligations is bound to make in its legislation such modifications as may be necessary to ensure the fulfilment of the obligations undertaken. From this case, we learn that when a nation enters into a treaty, it impliedly undertakes to make whatever changes to national law are necessary in order to give effect to that treaty.